Good morning. For those that don't know me, my name is Dan Fitzgerald. I'm a partner in the Greenwich office of Cummings and Lockwood. I know that everyone hates a movie with a sad ending, but as the last speaker today, I've been asked to talk about planning later in life for clients that are near the end of their life. I'll admit up front, this is not going to be an uplifting presentation because literally all we're going to talk about is death and taxes. But these conversations that you have with clients that are facing their own mortality will be some of the most sensitive and intimate conversations that you ever have with a client. You're going to need to use your knowledge of that client to try to figure out which of these ideas should be mentioned, which of these should just be better off going unsaid. Each of your clients is going to face their mortality in their own way. Some will freeze, some will go into denial, some will focus on saying goodbye, and some will actually want to work on their estate plan. To set this conversation up, I want to tell you a real life story, another movie with a sad ending. A client of our firm was in his late 50s. He had a wife and teenage children. He was a doctor by profession and saw himself as an angel investor and had invested in medical startups all over this country. This profile wasn't unique to us. We've seen this before, but what made this situation unique was 6 years ago, he didn't feel well. He went to a doctor friend who was a cardiologist, and he had some scans. And the doctor said, everything's okay. You're going to be all right. There's nothing wrong with him. In reality, his friend, the cardiologist, didn't have the heart to tell him that he had a degenerative heart disease and was going to die within 4 to 7 years. This client went through the last years of his life without expecting any of this, didn't know about his condition, and died in 2017, shocking his family. So my goal today in this presentation is to convey to you what I would have emphasized to my client back in 2012 if he had known about his condition and the steps he could have taken to better structure his affairs in the anticipation of his death. Don't get me wrong, this is stuff we tell every client, but in this estate planning life cycle, it takes a little extra importance. What you might not realize from today's presentation is a large part of Cummings and Lockwood's practice is actually the estate administration process. We actually spend about 50% of our time handling estate administration work. In addition to our lawyers, we have in-house fiduciary accountants and paralegals that do nothing but estate administration work, and this deep bench on the estate administration side really gives us great insight to be better estate planners and to make sure that we take care of both the legal and practical considerations in preparing for someone's death. So again, hopefully this presentation can be some sort of checklist for you after you get that call from your client that they're either have a terminal diagnosis, or for your older clients that are maybe in their 80s or 90s where there's just no denying the end is near. So my first topic on my checklist is simplify. As I mentioned, this client enjoyed angel investing and had something like 20 private partnerships and investments. Each of these investments generated a K1, but not always in return on investment. If someone passes, the executor or trustee is going to have to re-register all these investments, and valuations are going to have to be done for estate tax purposes or probate purposes. So what I would have suggested to this client, if I had the opportunity to do that, is that he should keep those investments that he truly believes would have paid off, and he should cut his losses on some to minimize the work that would be done after he was gone. Similarly, many clients have brokerage accounts all over town. They have one advisor for their equities, one advisor for their bonds, and maybe a third advisor for alternative investments. At this phase in the estate planning life cycle, it might make sense to consolidate all those accounts into one brokerage account. Hopefully that consolidation happens around the broker or advisor that's going to be for the quarterback for the family as they go forward. Another recent experience I had of just talking about simplifying things, I had a client living in an assisted living facility. They owned about $4 million of shares of their former employer, but the client owned it in paper form. And the paper shares literally sat in his drawer at the assisted living facility. So when his son called me and told me Dad was not doing well, the first thing, and I blurted it out without even saying, I'm sorry to hear it, is get those shares out of that desk drawer and get them into a brokerage account. Again, consolidation can really minimize the administrative aggravation as you go forward. The client, as part of this process, should take an inventory. Use that in quotes. It's my term. The client should take time to write down on paper, not on a computer, each of the financial accounts, the names of the advisors, the contact information, the approximate value. After a client dies, either the surviving spouse or executor are going to have to figure out all this information. So it's really helpful to leave an updated roadmap. The estate I mentioned before, the spouse had no idea about all the investments, had no idea how many brokerage accounts her husband had. So really, the only way we figured it out was picking through old tax returns and monitoring mail correspondence to try to figure out all the investments in the decedent's name. This day and age, the list or inventory should include passwords for computers, social media accounts, and potentially any cryptocurrency. We've had a couple of estates where people have significant crypto positions, and someone needs to know the client's key to be able to access these funds. So it's really important if you have clients with those positions, you talk about that and how that will work. If the client hasn't already done so, they should make their domicile very clear. I've harped on in years past at this seminar about the relevant tests for your clients when they're going to face state estate tax is a domicile test. It is not as simple as counting your days present in Connecticut or New York. As Rachel mentioned, there's a dozen states plus the District of Columbia, so moving to a no-tax state and being domiciled there can avoid state estate tax. The client can only have one domicile, and determining that domicile is a really hazy standard. Courts try to determine, where the client's intention to make the center of their social, domestic, and civil life. It requires not only a physical presence, but that intention component where the person makes someplace his or her permanent home. Steps including, if they haven't done already, transferring their voter registration, their driver's license, changing their church or synagogue, filing the income tax returns with the new address, updating their estate planning documents to make sure that they reflect that domicile. For those of you that have snowbird clients that keep a house here in Connecticut and they never use it, right? And maybe it does or does not make sense to sell that property, but if it does make sense for income tax purposes, the client should consider selling that house, right? Because if you have real property in Connecticut, even if you're a non-resident, you're going to have to file an estate tax return here in Connecticut. And that's normally the hook that the Connecticut DRS is going to use to try to argue that the entire estate is subject to Connecticut estate tax. Another important step, and this is a soft step, make sure the client's estate plan's in order. Any of today's speakers, maybe short of Kathleen, can draft you one of the best estate plans in the world, but unless the client has titled his assets correctly, he's made sure that his assets are either in his revocable trust and his beneficiary designations match his estate plan can still be easily defeated. So for your clients that do have revocable trusts as part of their estate plan, make sure these trusts actually get funded. The clients, we often offer to assist clients in this process, but they often take these tasks on themselves, and as you know, that normally ends up on the never get done pile. The costs of avoiding probate are often exaggerated, but funding the revocable trust can avoid any freeze period upon death where the assets cannot be accessed or managed. To give you two extreme examples, it may only take the Greenwich probate court about a week to 3 weeks to get an executor appointed, but if you die right across the border in Westchester County, you're looking about 6 to 8 months in the Westchester County Surrogate's Court to have someone appointed as executor. Again, during that time, no one can make trades, no one can access the decedent's funds. My example estate, everything was in the husband's name. The wife had no idea about these accounts, so she not only could she not get access, but she couldn't make any investment decisions or change investments. Luckily, it was during a time where the markets were moving in the right direction. It's easy to retitle the investment assets into a revocable trust, but the client should also consider retitling any tangible personal property, re-registering any cars or boats to the eventual beneficiaries. We often encourage clients to write out a memorandum or letter of wishes with respect to the division of tangible personal property. While again, not legally binding, these letters can often diffuse family disagreements over those items that may have no commercial value but are loaded with sentimental value. Fortunately, I'm involved in a situation right now where we're literally all arguing over a $5,000 piece of tangible personal property, and we've probably spent 3 times that in legal fees, but it does happen. The client should also double and triple check any beneficiary designations on their retirement accounts and life insurance. Somewhere between planning in the early years that David Thal discussed and planning in their later years, clients often fail to update these for the death of a spouse, the divorce of a spouse, or death of a child, or even if they've updated their estate plans, they haven't updated those beneficiary designations to match their current estate plan. So again, something that should be pulled and double-checked to make sure the client's first spouse is not the beneficiary on an IRA or an insurance policy. The client should consider making his funeral arrangements in advance, or at least arrange for funds to be available for funeral expenses. It may seem small, but again, these are the small items that lead to family feuds. In their estate planning documents, the client should review current fiduciary appointments to see who their executors are and trustees, to assess whether the folks or institution's names still make sense given the current situation. In this life cycle, it might really be the last will and testament, so it's important to get these right. And when facing a terminal illness, clients should focus on their living will and healthcare proxy to make sure it accurately reflects their wishes. And it's important to have their talk with their family about the realistic outcomes ahead. So as I mentioned, some, when facing their mortality, will want to get to work. This may involve saving some potential income or estate taxes. With the new higher federal or Connecticut exemptions that Rachel discussed, you're going to see a real shift in estate planning, where estate planning for certain folks is going to be more about saving for income tax purposes as opposed to estate tax purposes. Even if you pay no estate tax due to those higher exemptions, the beneficiaries still receive the benefit of Section 1014 of the Internal Revenue Code that says assets passing from a decedent will receive a basis adjustment equal to their fair market value of property as of the date of death. So for a lot of older clients that have low basis assets, the right planning might just be to hold that asset to get a step up in basis at death and avoid capital gains. If you're dealing with a married couple, some analysis should be done to best position those assets for the step up in basis. When positioning assets to maximize that step up in basis, keep in mind there is a limited window after a terminal diagnosis to shuffle assets between spouses to best take advantage of the step up in basis, because 1014E says that if a decedent acquires property from a person within 1 year of death and that property passes back to that same person, there will be no step up in basis and carryover basis will apply. So this means if a healthy spouse transfers assets to a terminal spouse and the healthy spouse receives that back, and that transfer, the first transfer, happened less than 1 year, you're going to have a carryover basis and no step up in basis. However, you can still make these transfers within 1 year if the assets are going to go in another direction, say to children or to trusts for multiple beneficiaries. For those of you that have clients who set up irrevocable gift trusts during their lifetime, or some of the trusts that Dan Johnson talked about, those trusts are normally grantor trusts, and for income tax purposes, that means the grantor pays all the income tax on it. Normally, one of the most common powers that causes it to be a grantor trust is the grantor retains the power to reacquire assets of equal value by substituting that into the trust. So when a client receives a bad diagnosis or is in their 80s or 90s, these trusts should really be cleansed of any low basis stock by exchanging assets of equal value. This will allow the low basis stock to get a step up in basis upon death, since it will be in the grantor's taxable estate. And whatever you put into the trust will have hopefully a higher basis when it will be subject to income taxes in the future. Finally, for those facing either federal or state estate tax upon their death, they should consider making deathbed gifts. Again, this is a sensitive issue, and you'll have to judge your client best to mention whether this is worth talking about or not. Clearly, the client should be making any annual exclusion gifts as soon as possible each year. The check should be written January 1st or January 2nd. That $15,000 per year can be spread across as many family members as possible. Similarly, the client should be making any tuition payments for children or grandchildren to take advantage of that freebie. As Dan Johnson also mentioned, there's a clear distinction between the gift and estate tax, even though the system's unified. Gift tax is tax exclusive and the estate tax is tax inclusive. So making large gifts can decrease the overall taxes due. Caveats to mention, again, carryover basis. When you give appreciated property, you're not going to get a step up in basis. The beneficiaries are going to have that carryover basis. Also, a client needs to be sure that they don't give away more than what they're going to need for the rest of their life. None of us at Cummings and Lockwood is ever going to tell a client that they should give away more than they're comfortable. As I think someone used, if you have butterflies in your stomach, you shouldn't do it, and that's a great analogy. There is a code provision, 2035B, that says federal gift tax paid within 3 years of death will be included as an asset of the estate on the estate tax return and subject to estate tax. While its provisions intended to prevent folks from giving away assets shortly before death, keep in mind it does not capture the complete picture, right? By just bringing back the tax paid and not the value of the gifts or the assets as of the date of death, appreciation from the date of the gift and the date of death will still escape state taxation. And as I mentioned earlier, there are a dozen or so states with state-to-state taxes. Connecticut's the only one with a gift tax. For those of you who have clients residing in a state other than Connecticut, large gifts are a tremendous savings opportunity for state estate taxes. Each of these states have a tremendous loophole in their estate tax, right? If they give everything away before death, there'll be no estate tax. There is a quirk in New York that for the next month, gifts made within 3 years of death between April 1st, 2014 and January 1st, 2019 will be brought back into the estate, but that's just going to be around for another month. So if the client's comfortable, taxable deathbed gifts can make sense. And to illustrate this, I have a numerical example. While these numbers look large, these are actually from a recent situation. I've obviously rounded the numbers so they're easy to read. On the left, you have Jesse's Ebenezer Scrooge, who died with $250 million living in New York. He didn't make any taxable gifts during his life, so his federal estate tax is just under $80 million. And the New York estate tax, $40 million. Now on the right, you see that the ghosts of Christmas had their intended effect, and Mr. Scrooge gave $100,000 in taxable gifts and survived 3 years after the date of the gift. Mr. Scrooge had to pay a $35 million estate tax after exemptions in April after the year of the gift. But by making this gift and paying that federal gift tax, when he dies, his estate's now only worth $114 million. He's lowered his federal estate tax down to $38 million, and the New York state tax down to $17 million, which produces an overall tax savings on these numbers of $27 million. 22 of that 27 is strictly the New York estate tax savings. The rest is really from not paying estate tax on the $35 million that went to the federal government. So keep in mind, in reality, that the savings when we did this technique for the client were actually much larger for 2 reasons. There was appreciation between the date of the gift and the date of death, and also we would structure a transaction like this to take advantage of fractional interest discounts, so the actual tax savings was a lot larger. So that ends my formal remarks. Thank you for coming today. And then also, we are actively posting updates on our website and LinkedIn, so please follow us on those platforms. Thank you.